With the research that I've been doing lately in regards to all of these things, it was interesting to find out that if you go to court, you just got all your, where they're turning around and saying, well, I'm the living being known as, okay, they're getting that part right, okay, of the dead entity is what they should be saying. Because the minute they turn around, you turn around and say of the dead entity and give the surname, right, there's no case anymore because you can't prosecute a dead man. So you just removed the principal out of the case. They're now dealing with the agent, and the agent can't sign on anything.
So you could send that as a first appearance sort of thing, as a response.
You could literally, well, you can literally get out of it by turning around, and if they were to turn around and charge you or something, you can get out of it by doing a letter in regards to it first. By using those same principles, you can get out of it by using a letter, because at the end of the day, they can't bring a charge against a dead man or a dead entity. Yeah, so that it's one of those unusual things. I was reading up on the dead entities and stuff like that, and it's amazing how that's literally why all your name is in caps lock on a court document. Yeah. Because if they don't do it, if they don't use your first, like if you've got a first, middle, and surname, all of it's got to be on the document. So the trick to it is, if you're going to turn around and claim in regards to that, use the first and second name that they've used as the living being, and the dead entity as the surname. Okay, and because there's a dead entity, there is no principal to prosecute. There is only the agent there. So you can't. It's under the Contract and Commercial Laws Act. So for being able to do those sorts of things, you have to implement that particular section of that act. And what you're saying is you don't have the ability to contract because the entity is dead. And it is only the living being.
Do you know what section of the Contracts and Commercial Laws Act that is?
I think it was, hold on, I'll just go and have a look. I think it was section 40 or something like that. Section 40, because what ends up happening is section 36 to 39 have effect in place of the common law, of a place of rules of common law and equity. So what you're doing is you're removing out common law.
I'll just do a share screen.
But yeah, section 40 tells you that sections 36 to 39 of the Act come in place of common law. And so where it says, so a party that's, any party that uses that, as it says there, which a party to a contract may rescind it or treat it as discharged for misrepresentation, repudiation, or breach. And then what you do is you implement the Crimes Act 1961, section 240, because that gives you the ability to say there was misrepresentation.
Yeah, for sure.
And so by doing so, by implementing that particular act and section, what you're saying is anything that they just brought against you, because it says there rules of common law, so anything they just brought against you is now able to be discharged or rescinded by you because of the fact that that takes place over common law.
Yeah, because I think that's in the Imperial Laws Act, something about the laws of equity.
Yep, that's the section 6A subsection 2.
Yeah. Wow.
Because I noticed that the Imperial Laws Act was a very, very tiny act, and it's in regards to things like the Magna Carta and all of that type of stuff. But when so basically what it does is it goes Imperial Laws Act section 6A subsection 2, then leading into the Secret Commissions Act section 5, then the Contract and Commission Law, the Contract and Commercial Law Act section 40, then the Crimes Act 240.
Okay. All right, sorry, I just found it here for us. So we're talking about this puppy here, yeah?
I don't know, I can't see anything. Oh, yes, so how it's got, hold on, which one's that? No, that's section 6.
Sorry?
Oh, yeah, 6. There should be a 6A. Is there a 6A?
Oh, yes, there
or
is.
Or would I read it wrong?
No, you're right, you're right. There we go.
Yep, 6A, yep. If you look at subsection 2 of that, right, See how it says the Legislation Act under number 1, then it says secondary legislation in bold. So all other New Zealand laws, laws of New Zealand, is secondary to the Legislation Act 2019. Under Section 5 of that Act, it tells you that all of the other ones are subordinate legislation.
Yeah, for publication requirements.
So by implementing the Imperial Laws Act, you're actually overriding everything, including the Bill of Rights.
Yeah, Imperial Laws Application Act.
Yeah. So what you're doing by doing the this Act and then Section 5 of the Secret Commissions Act 1910 is.
That one. I might as well have a look at that one as well. Hang on. Secret
Commissions Act. There you go.
Who would think that you type the word secret and it comes up straight away on a legislation?
Who would think in legislation you'd have a Secret Commissions Act?
I know, right?
Yeah. See, now, if you look down at number 5, duty of agent, right? So this is where you get the agent part from. You see, the court's the agent and the principal's not in the court. So therefore, the agent doesn't have the ability, how it says existence of pecuniary interest. The agent is doing it on pecuniary interest as the principal is not there. So the principal doesn't know what the agent is doing. And so therefore, what it means is, like, if you go into a court situation, if you have a lawyer, okay, the principal's in the courtroom. However, if the principal being the defendant doesn't agree with what the agent being the lawyer is doing, okay, then there can be no contract.
What's this about the pecuniary interest?
So the pecuniary interest, okay, is basically, from my understanding, is this. Okay, there's a pecuniary interest when the agent is acting on behalf of the principal, but the principal doesn't know what's going on. It's like me saying to someone else, "Go and see Mark, and he'll give you $500." They turn up and you go, "I have no idea what you're talking about." That's the pecuniary interest.
Right. Because I'm the agent and you're the principal doing that.
No, if you're the principal and I'm the agent and I'm telling someone to come and see you for it, okay,
right,
and you've got no knowledge of it, the principal has to have knowledge of what is going on.
Got it. Other way around.
So without the principal there, it's like, if I suppose an easy way to put it is, it's like when you go and you sign a deal for a car and you get on hire purchase. The hire purchase company's got an agent that signs on their behalf, right? So the reality is, you can actually say in those sorts of agreements, well, are you the principal owner of the company? No, I'm not. Then I require this person here, because they don't know. How do I know that they know you are signing on their behalf?
Yeah, no, I get that. Now we're going to drop out in about 5 seconds, so I'll send you another link.
Okay, all good.
All right. Oh, it said 40 minutes, but remaining time. Sorry, remaining time 2 minutes 30 seconds. We can keep going.
Okay. So yeah, no. So going through these different acts is the way of being able to implement it in multiple different forums. Like if you were dealing with, for instance, a parking fine, right? You can literally turn around and say to them, well, yes, you're saying you're the issuing officer, however, you're not the principal, and the Secret Commissions Act 1910 requires the principal to send that to me. You're not going to be able to do that because you're not the principal. Therefore, the contract is null and void, and so the ticket is too.
Oh, I wish life could be so simple, but I mean, it makes perfect sense when you're saying it like that, but it's knowing how to implement it on paper.
Yes, and that's why, like in the court on Friday, I said what I knew of, issue preclusion, right? And got to look like, what the hell are you talking about?
What would happen if you hadn't have said that? Or, I mean, because I know it was because you wrote something similar to the preclusion in your paper.
Yeah, I put today in the modern world, it's known as issue preclusion, right? And so, or collateral preclusion. But however, the courts here know it as estoppel of preclusion. So it just depends on what country you're in and stuff like that. But what happens is, if you don't have that knowledge and you don't, or if you do have it and you don't implement it, okay, then everything the other parties just said about you, if it was part of another case, is still valid in the current case, because you did not state it was subject to estoppel of preclusion.
Yeah.
you know, and to actually be told if I hadn't stated that, all of the submission would have been taken, you know, into account and, you know, and considered. So really, what it means is, like, if you're like in a family court case, for instance, and you've had previous judgments over the years, they use them all against you all of the time. They just keep bringing it up, right? And so the way to be able to stop that is, well, and the way I would word it is, well, the court should be well versed in the fact that the matters you're talking about have been subject to proceedings that have received a judgment or determination, and therefore are subject to estoppel. Other people that had let me know about this sort of stuff have implemented it in a completely different way. And so what I was looking for was a way of being able to implement it in a shorter, more, how do you put it? Something that's just easy to portray across.
Sure.
And so I've pretty much got it down into a letter form now. I just got to put the document, the write-up in that I need to put into it to be able to send it. But it's just, you know how when you first get the knowledge of something, and then it just takes a while for it to sink into the brain, you know, with a whole pile of different sections.
Absolutely, mate. You've got to sort of try and get all your marbles in the right size and order.
Well, yeah, but what I find is once we do get them in order, that's when the authorities don't like it, because we're coming back at them with stuff that, oh my God, okay, you're not supposed to know that.
Well, you might get 80% of the entire fucking bullshit dropped off in one little sentence.
Well, yeah, and that was what amazed me was like when it came down to that, I was told that, okay, I didn't have the particularization, you know, down thing, because I'm so used to now having dealt with appeals and that you do it all within detail. But when you first bring in a case, they're expecting you to go into elaborate on it majorly to give a full story. But I really don't see the point of it.
Sure the court knows everything about it and make sure they're fully informed, so they're just going to elaborate till the cows come home. And
yes, but then you get people like another lady that I've been watching her journey, where she's put hundreds of pages of evidence into a private prosecution. You know what the judge came back with on it? It is not a requirement for me to look through all the documentation and see if there's any evidence. It's up to the plaintiff to do this. It's like, get off your ass, you lazy old bugger, and pick up that paperwork.
Yeah, exactly.
But you know, it gets a bit confusing sometimes, because you get some of them that just go, I'm not going to look at the documentation like that particular one.
Yeah.
But then you narrow it right down till you've got the evidence you require. And I mean, like when I spoke to a lady called Judith, as she said, she had one client that had 2,000 pages of evidence, or so they thought. But by the time she went through it all and applied the two-step process to it, there was 10 pages. But that 10 pages was all that was needed for the defence.
Yeah, that's right. So the hundreds and piles of pages mean fuck all when you only need 10 to prove your case. And it's the old
because
it's more sometimes.
But what it really comes down to, and this is what I've worked out over time, is when you are looking for evidence, okay, we all look for the fact of, well, this says I was here. But we're looking for the wrong thing. What we're looking for is the thing that says I did not have any direct or indirect involvement in this matter.
Right.
And so as long as you can show that, there is you mitigating what they're stating.
Yeah. And
so they're turning around and saying to you, well, you were around at this time, right? And you turn around and say, no, I was at, say, for instance, you might have been out of the country, for instance, okay? Right. But being out of the country to them is not a defence. What it is it just says you could have turned around and booked the trip out and then not taken the trip, right? So what you're actually trying to show is, okay, it's not that you left the country, it's you turn it around on them and go, so you say I did this to this person, yeah, show me my direct or indirect involvement.
Yeah.
Now it's not, the onus is not on you to prove your innocence, it's on them to prove your guilt.
Yeah, of course. I do that in the speeding tickets in court. I just say, well, just tell me who the hell was driving, please. Can't say who was driving in the photo. Who was it? Out,
Yeah,
out, of,
and you see,
out of the
right there and then,
out of the 762 tickets you issued in the 3.5 hours on the motorway that day, can you point out that it was me at that time? Did you see?
and that's why. So what you're saying is exactly what I'm saying. Show me the direct or indirect involvement.
Yeah.
Because if they can't prove it was you, they can't prove that it was directly you or indirectly you. And so therefore, see, like when we turn around and say to them, you prove that it was me, right? There's no such thing in law. Show me the direct or indirect involvement I had. There's your case in law.
Yeah. Because I mean,
so it's what I've learned over the last 3 years is that it's all in the wording.
For the speeding tickets, it's all the lawyers say. Look, they already know that it was your car. They've got the plate. They already know what time and day, and they've got the photograph to show that your car was doing that speed. We just need to know, were you the driver? And as long as I don't go, look, mate, no, I wasn't going that fast. Boom, I'm the driver. If I just say, look, I wasn't going that fast, or I don't believe it's accurate, or I was in the other lane. Either way, you're just saying you're the driver. I believe I don't have to help you with your investigation. Can you please tell me, beyond a reasonable doubt, was that me? And they can't.
Yep. The easy argument for that in law, you have not proven my indirect or direct involvement.
Again, it's all just the phrases, isn't it?
What I've learned is it comes down to, like, when you look at sections of law, it also becomes like people look at it and go, well, it's contained within this paragraph. It's the context. No, it's not. It's the words in the paragraph. So, for instance, if it comes down to say it says we will give a person a ticket or an infringement notice if they are within 4 k's of the speed limit, right? Prove I was within. Never mind the rest of the paragraph. Prove I was within, directly or indirectly. It's not the rest of the paragraph that matters. The word within is there.
Okay.
We must prove. Show me the must part.
Okay. Yeah. It makes perfect sense. It's just and a lot of them will argue, oh, we're not going to play semantic games today, I'm sorry, Mr. Andrews, but I'm not going to argue whether it's lawful or legal with you today.
So then you come out with this question. Your Honour, are you an agent of the Crown? Yes. Your Honour, are you sworn to uphold the statutes? Yes. Well, then I believe we're dealing with this matter today.
Why wouldn't he want to?
No. Because those 2 questions, when you look at law, because I was watching a couple of other videos, but those 2 questions, when you look at law, require the judge to answer yes. And if he's there to do those 2 things, from there on, you can refer him to any legislation you want to. Yeah, it doesn't have to be in regards to the legislation that they're dealing with. You can move on to the Secret Commissions Act. You can then move on to the Contract and Commercial Laws Act. Then on the Police Act 240, right? Now they've no longer got a case because they misrepresented and the court's required to uphold those statutes.
Yeah, so I used to start off with, Your Honour, are you to be a fair, independent and impartial adjudicator here today? I mean, they have to answer fucking yes. But the way it's on the record.
Yeah, but if you're asking the question, are you an agent of the Crown? You're removing the agent from the case, so they can't make a decision because they're not the principal.
Yeah, so
the principal is required to make the decision. It's an interesting factor in the way they've done the law, because nobody knows that they're an agent of the Crown, and therefore the principal that's pretty, like, when they turn around and they'll say in a criminal case, the Crown or the Queen versus this person.
Yeah,
it cannot possibly, but it can't possibly be that, because when you look at law, there's a prosecutor there that's an agent of the Crown. There's a judge that's an agent of the Crown. Nobody in the courtroom is the principal, which is the Crown. So how can the Crown be prosecuted?
And the judge will say, well, I'm representing the Crown today. I'm here.
Exactly why you've got the agent of the Crown, and the agent can't represent on behalf of the principal. Principal has to be there in law. So it makes every courtroom around the world basically a sham, because at the end of the day, if the principal's not there, how is any decision making getting done? Because by law, under the Secret Commissions Act, Section 5, the agent can't make any decisions on that day. It's got to be the principal being present.
Yeah, well, I doubt the Queen's going to be sitting there on the hotline saying, "Yep, no, hang the fucker," you know.
Yeah, but even if they were, they're not physically in the room, so they can't do any judgment. That's the interesting part about the law. And why do they get away with it? Because nobody knows. I didn't know about it till in the last, 4 or 5 weeks. But it's like I say to a lot of people, you know, at the end of the day, people sometimes turn around and say, oh, you know, there's people out there that think they know it all. You never know it all, because there's always something else that comes up. Yeah, but it's always good that when you get there,
that some other smart bastard knows that you don't as well.
Well, yeah, I mean, like when it comes to the Imperial Laws Act, Imperial Laws Application Act, I didn't know about that until about 5, 6 days ago. I was watching one of the Bill Turner videos, and it was him that was going on about the Imperial Laws Act. So I read up on it. It's like, okay, he's right. However, it's 6A subsection 2 we want, because it makes everything else secondary legislation. And so when you look at it from that point of view, we've got primary jurisdiction, secondary jurisdiction. We've got primary legislation, the Imperial Laws Act, Imperial Laws Application Act, and then everything else is secondary. So it was, for me, it was quite interesting to find out even the Bill of Rights is secondary.
So the fact that that's all secondary legislation just means it can only be dealt with, where it can't.
So we all know it as primary legislation with all the statutes, right? But until you know that you can implement the Imperial Laws Applications Act, that's when everything else becomes secondary. So if you implement that particular act first, like everybody's saying, use the Secret Commissions Act. However, that's secondary legislation too, because you've got the Imperial Laws Act, Application Act. So if you implement the Imperial Law one first, you can then lead into the others, because the Imperial Laws Act's the primary one. So you can lead into this, all of the secondary statutes, and you're able to then show misrepresentation.
So okay, so the whole point of making everything secondary legislation is to show that it's been misrepresented towards you.
Well, yeah, because what it ends up being, so say for instance, if it's the Crimes Act that you're going for, right? So they bring you to court on a charge under the Crimes Act, right? But under the Imperial Laws Application Act, Section 6A, subsection 2, you're aware that it's secondary legislation. And so because of the Secret Commissions Act 1910, Section 5, you're aware that the man or woman sitting behind the bench is an agent of the Crown, not the principal. And therefore, because of that, you implement the Contract and Commercial Laws Act, Section 40, stating that, okay, the person behind the bench going by as being an agent is going on common law. But the Contract and Commercial Laws Act, Contract and Commercial Laws Act, at that Section 40, because you're removing the common law, you're now removing anything they're able to do, right? And because of that, because you just removed common law,
going back to the law of equity, yeah.
Yeah, so you're going back to the law of equity. So therefore, the criminal charges you're now on under the Crimes Act, right, under the Section 240, were misrepresented to the court. They must be now discharged.
that's just fucking beer. You're literally ripping one hat off of the judge and putting another one there.
Yeah, exactly. Yeah. So see, everyone else is saying, you know, the fiduciary part, but I'm looking at it from the point of view, you don't have to implement all of that stuff. If you stick to those sections, the judge does not have any jurisdiction to deal with it. Why? Because it was misrepresented under the Crimes Act. And if it's misrepresented under the Crimes Act, okay, as it says in the Section 40 of the Commercial Law Act, right, because of that, you're able to either rescind it or discharge it. So if you rescind it, it never existed. If you discharge it, it's gone. And why is that able to be done? Because under the Crimes Act 240, it got misrepresented to the court in the first place, because the Imperial Laws Act is the primary act.
And and by presenting it to the court in the fashion that they did, are they trying to present it as primary legislation?
Well, no, what they're doing under Section 240, how they're bringing you on criminal charges, right?
Figure out how the misrepresentation is.
So the misrepresentation occurs because you got charged with something, they bring you to court under that legislation, remembering that secondary legislation.
Under the land
so by implementing the Imperial Laws Application Act as the primary, it says everything else is secondary, right? So by then moving on to the Contract and Commercial Laws Act, that Section 40 says that common law doesn't apply under Section 36 to 39. So if you've got no common law, you don't have common law to uphold a statute, so you misrepresented it under the Crimes Act in the first place, because you haven't got common law to go on. Whoever's trying to prosecute doesn't have common law to go on anymore.
Yeah.
So that's how you get the misrepresentation.
Got it.
So therefore, who becomes liable now? We're back to the prosecutor again.
Well, the prosecutor, and because they're the trustee, they have to fucking deal with it.
Yes, but if you don't have to, like the other guys that are dealing with it from the trustee stage, you don't have to turn around and do it in the trustee way the way that I've just explained it, because the person who filed the charges with the court is stating that those charges are true and correct, and that's where you get misrepresentation from. They didn't have the common law to implement the statute in the first place.
And by doing that, they're also acting in bad faith.
That's right. So you get them on multiple levels. Because you remember ages ago, I was telling you that when my daughter went to the High Court, we judicial reviewed the place of safety warrant. And the Crown Law representative stood up and went, "But Your Honour, that removes the power, the statutory power." And he was told, "Yes, this will be an interesting case." Because you're going back to common law, but you need common law to then implement the statutes. So if you're removing common law through Section 40, how are you implementing the statute? You misrepresented in the first place.
Yeah, you're ripping out the first couple of rungs of the ladder. Really, they can't get.
Yeah, so you're not taking actually anything away from the judge or the court. But what you're saying is, number one, the judge is an agent under Section 5, but the prosecutor brought a false, misrepresented claim of charge. Because it's under the Contract and Commercial Laws Act, 40 removes common law. So if there's no common law, you can't have implemented the statute to give the charge. You misrepresented to the court.
So can all of that go on a simple piece of paper in the hand of the court without you speaking, or do you have to speak?
Yes, in a simple letter. You just put it in a simple letter to the court stating all of that stuff. The court's going to turn around and say, well, no, you've still got to appear more than likely, but you put your argument forward, then you just have the same argument in the court. Because at the end of the day,
the word appear is a memorandum. So if they want you to appear,
the other thing you've also got to remember, you need to appear. Sorry, but I don't want to accept your invitation. Just the same as I've done with the government agency the other day when they emailed me back and said you are required to appear. No, I'm not.
It'll be you're required to attend.
Yes, but even if you're required to attend requires that appearance.
Exactly, but you can.
But either way.
Yeah, I get what you're saying, but you can file an appearance in attendance. So
you can under what is it? I can't remember which. I know it's one under family court rules, but there is a district court rule that you can protest the appearance as well. But you don't need to protest the appearance, because what you're saying is the man or woman that I'm about to appear in front of, okay, has no jurisdiction because they're actually the agent of the Crown. Yeah, and so without the principal being there, they're not able to do anything. But in turn, they can't do anything in the first place because the charge was misrepresented. Yeah. So by having the misrepresentation there, there's no charge anymore. So how they always say innocent until proven guilty. Yeah, okay, that's fine. But at the end of the day, you can't be guilty. You can't be innocent or guilty if it was misrepresented in the first place. Oh
yeah, the facts have to be fucking sort of
Yeah, but they've misrepresented the facts. So by implementing that Contractual Law Act part, the Contract and Commercial Law Act part, the Section 40, that's the helpful part because you've got no common law anymore, and you need common law to implement a statute.
Yeah, so it's just putting them all on paper in that nice, simple fucking fashion.
Yeah. So what you're doing is when you first put it, the agent, are you an agent of the Crown? Are you sworn to uphold statutes? That's where that misrepresentation comes in as well. Yes, they're sworn to uphold the statutes. However, common law's gone from Section 40 of that Contract and Commercial Law Act, so therefore there's no statute to uphold. So the police misrepresented the charge because there was no common law to do it with.
Right. Fuck. Okay, you know I'm going to get...
I could honestly say at what, for nearly 52 years of age, I did not expect to be looking at all of this sort of stuff. You know, I didn't even learn any of this type of stuff at school.
No, and why would you? But then a well-informed public isn't something they want. So, I mean, I've always...
Well, that's right, yeah.
So more from fucking kindergarten, as far as I'm concerned. Just the basic or Latin.
You know how people get taken to like small claims court and stuff like that, right?
Yeah.
It also works there. Why? Because it's based on common law.
Of course.
Yeah. So anywhere you've got an adjudicator, human rights tribunal, the privacy commissioner, all of them, they're all agents of the Crown. So they don't have the principal there to do anything.
And the principal is the Queen.
The principal's Crown, yeah. Not the Queen, Crown.
Not the Queen. So what happens if someone shows up and goes, "Hi, I'm the Crown"?
I'd love to see one of the old kings show up because they were considered the Crown back in the old days. But you're going all the way back to Magna Carta.
Yeah. So
you're not going to get a principal turning up.
So the Queen would literally have to be in the courtroom.
No, because she's the Queen. She's not the Crown.
Okay. So who's the? Sorry, I'm just trying to nail down who the Crown is. Then.
So going by my understanding of it, if you go all the way back to the days of Magna Carta and stuff like that, where they had the kings back then.
Yes.
That's the Crown. So the crown is what she's wearing on her head.
Okay, so it's not the Queen; it's just the crown there.
Yeah, and so there's no principle. See, so you can never have the agent is the court is the agent of the Crown, not the Queen. So we put it this way: when the Queen dies, the Crown's still there, so the next royal gets inducted in as being the Crown.
Yeah.
Right. So the Crown can never make an appearance because it's worn on a head. It's the head of state. So that's the Crown.
Yeah, which is why we see.
So it's impossible. It is actually impossible to have the principal when it comes to Crown present at a courtroom because there's no way a Crown could sign a document.
Yeah. Oh my God. It really does put a bender on it for most people. So that's a get out of fucking jail free for fucking anything.
It's pretty much is, yeah. But it's a case of, I've been told that there has been people that have tried to implement and failed, but then I do know of a couple of cases where the people have implemented it and walked out of the courtroom and a judge has turned around and told the bailiff not to stop the person as they're leaving.
I'd love to see that recorded. I really would.
Yeah.
Yeah.
But it's an interesting way of looking at things because if you implement it in that way, then there's nothing that they can really do.